Everyone. First, aside from welcoming everybody today, I want to say Happy New Year. We have not met since 2021, and between then and now, a lot has happened. A lot of good things has happened, and there is a lot more good things to come. So, having said that, I would ask the clerk to do the roll call, please.
Chairwoman Williams,
Present.
Representative Pagello,
Present.
Bella Robinson, Robin Lynn, Justice Gaines,
Present.
Charlotte Peters,
Present.
Dr. Philip Chan, Michael DeLauro, Kyla Pecchia,
Present.
Lily Pickett,
Present.
J. Leoshero Brantley, Henry Binks, and Sidney Wardell.
Here.
Robin Lynn,
Here.
Chairwoman, you have a quorum.
Thank you, Mike. I also would like for the record to clarify that Charlotte Peters replaces Jocelyn Foy of the Women Project. Kyla Pecchia replaces Kate Sabatini from Rhode Island Attorney General's office. Welcome to both of you. And at this time, I would like to entertain a motion. As you know, the first meeting we had, it was for electing the chair of the committee, of the commission. And we would like to, at this time, entertain a motion to elect the vice chair of the committee. So, who would be so kind as to take the lead to nominate the vice chair? And if no one's comfortable,
So moved, Chairwoman?
okay, I would need to place the name in order, which is Representative Edith Agello. So,
Sure, Chairwoman. I nominate Representative Edith Agello as Vice Chairwoman of this commission.
any second? I'll second it. Second by Bella Robinson. All in favor?
Aye.
Aye.
It sounds very unanimous, and I thank you all. Welcome, and thank you, Representative.
Thank you, Madam Chair.
Does everyone have a copy of the agenda? Okay. I just also want to make note of Bella Robinson had provided myself with some documentation for which I shared a copy with the vice chair so that we can review it at our leisure. And again, I say to any member of the commission, if you have any documentation, story, or individuals that would like to share their experiences or their documents with us, please note that I'm open to that, and that offer stands for anyone who is watching the commission, so that it's clear that I am certainly dealing with an open commission for participation, communication, and collaboration. We're going to take our time, we're going to do it right, and we're going to present it correctly. So with that, today's presenter is Mr. Stephen Brown. He's the Executive Director of the ACLU of Rhode Island. He is definitely an individual that comes fully prepared not only with what he is about to present to us today, on any topic that is brought to him or his organization. There is not much that I can say that folks are not aware of. He brings facts, always. He walks quietly but carries a big stick, always. But he's always open and willing to listen, communicate with whomever, whether they're on the same side or not. And that is very admirable of him. So without any further ado, I say, Mr. Stephen Brown, welcome. And please, the floor is all yours. But before you do that, I also want to say thank you, Bella, for the folder of all the goodies, the binder, I should say. And at some point, once we have done our due diligence with it, I'm going to come back to you so that we can go over it and bring it to the group, okay? Thank you. All right. That's my sister just came in there. She didn't even say hi. You're here, that's what matters. Oh, and you came right on. Yes, see, that's dedication, commitment. Can we have her recorded, please?
Yes, she's recorded. J. Layden, Cheryl Brantley.
Thank you. Without further ado, Mr. Brown, the floor is all yours, and please note, if it's okay with you, and members, if you need to ask a question prior to him finishing, are you okay with that, Mr. Brown, or you prefer
Yes.
prefer to finish?
The chairwoman's pleasure.
Okay, so commission members, if you're comfortable, you would just raise your hand or, signal me, and I'll recognize you so that you don't lose your thought with him going through. And then you can ask the question directly to Mr. Brown throughout his presentation today. I think it might be easier that way. Okay? Thank you. Please proceed.
Thank you very much, Chairwoman, and thank you for the very kind introduction. I welcome the opportunity to appear before this commission. We supported the passage of the resolution establishing it. It's unquestionably worth having a thorough examination of the costs in terms of health, safety, privacy, and many other things that we think are inflicted by the prostitution laws in this state, including their impact on marginalized individuals. Before I go into my presentation, I was asked to give a history of the prostitution law, what it means, where it is going. I want to make just 3 quick preliminary points. First, as I already mentioned, the ACLU has long opposed criminalizing consensual sexual activity among consenting adults. So while I hope to present a largely fact-based presentation today, I think you all ought to be aware that those facts are being viewed by us through this lens of supporting decriminalization. And there are at least 3 major reasons that the ACLU has had this position for so many years. One is the clear discriminatory impact that these laws have had on women in terms of their enforcement. What we consider to be a very broad invasion of personal privacy when we're talking about consensual sexual activity in private, and concerns about the enforcement techniques that have to be used precisely because it is a consensual private activity, and therefore it requires police to engage in various types of conduct that we think are inappropriate in order to catch people for engaging in consensual activity. Second, my focus is on Rhode Island, not on the national picture. I would note that 2 years ago, the National ACLU did issue a very thorough, detailed research report entitled, "Is Sex Work Decriminalization the Answer? What the Research Tells Us?" And it reviewed over 80 empirical studies that had been done analyzing the issues of the impacts of both criminalization and decriminalization of prostitution, And I would be very happy to share that report with members of the commission if you're interested in looking at it. I will just very briefly read the summary of the report, so you have that. The summary, the report concludes, the research points to negative impacts of criminalization on the physical safety, health, and financial well-being of sex workers, with repercussions for clients seeking consensual sex between adults. These findings are only amplified when specifically examining the impact of the criminalization of sex work on marginalized communities, including LGBTQ people, people of color, and immigrants. People without adequate financial resources, such as those living in poverty, are also more harmed by the criminalization of sex work. Overall, the evidence suggests that going from less to more prohibitive laws on adult consensual sex work is damaging to sex workers and appears to have little impact on curbing trafficking or other crimes. Conversely, as laws move down the continuum from more to less prohibitive or restrictive consensual sex work, workers experience less harm, and there is no strong evidence to indicate negative impacts on crime, health, or safety. I would note that a number of the studies that are in that report do reflect analysis of what happened in Rhode Island between 1980 and 2009, when the so-called loophole, quote unquote, existed in the state. And it found, I'm no expert on this, but it did, there were some really major findings in terms of the decrease in STDs, in sexual assault, and those are certainly worth looking at. But again, I claim no expertise on those particular issues. The third and final point I want to make before I get into the bulk of my presentation is just comments about terminology. I'll often be using the term prostitution instead of sex work, simply because that is what the laws refer to, that is what the court cases refer to. I will more often not be referring to women, not because obviously it affects only women, but because they have and continue to bear the brunt of the enforcement of prostitution laws. And then third, I will be quoting some brief excerpts from court opinions. And I just want you to know I made some little tweaks. I got rid of citations to statutes. I didn't change the substance in any way, but I just wanted you to let it know in advance that they may not be verbatim quotes. So there may be a word or two that I've connected and so forth. So getting right into it, I think any discussion of the history of prostitution laws in Rhode Island has to start with the case of Coyote versus Roberts, which was a lawsuit filed in 1976 by the national organization Coyote, as well as the state organization at the time, and it challenged the constitutionality of the state's prostitution law as it existed at that time. That statute made it a felony not only to engage in prostitution, but also to engage in any other lewd or indecent act. There were Rhode Island Supreme Court decisions looking at another statute that interpreted lewd or indecent act to mean something as broad as one could ever imagine it to mean. The Rhode Island Supreme Court interpreted it to encompass all extramarital sexual intercourse, as well as any quote-unquote unnatural form of copulation, regardless of marital status. It could not have been broader, but it was on the books. The Rhode Island Supreme Court had upheld its constitutionality in a number of court decisions, and that was also its interpretation for the prostitution law, which banned just not only prostitution, but lewd or indecent acts. The state statute that was challenged made it clear, and I'll just summarize the court's explanation of what the statute covered at the time. The court said criminal sanctions could be imposed without regard to whether the sexual activity was a commercial venture undertaken for financial gain, or whether the activity was undertaken in private with the full consent of two adult parties. The statute also banned what the court called preliminary or preparatory activities for prostitution. Again, these were all felonies, such as loitering to solicit, transporting, aiding or abetting a person to commit an indecent act, and similar things. Again, these acts were all felonies without regard to the public nature of the activity, the mutuality of consent, or the financial motivation of the participants. The challenge filed by Coyote was on two major constitutional grounds. One, that the act was overbroad and impermissibly infringed on constitutionally protected rights of privacy and association. Importantly, they did not challenge the public aspects of the ban. That is, they did not challenge loitering to solicit or other public prostitution offenses. Instead, they focused on this constitutional protection of privacy, that the act, solicitation for the act, as long as it occurred in private, was no business of the government. The second major aspect of the challenge was an equal protection of the laws challenge. They argued that the statute was discriminatorily enforced, in that even though the statute on its face was gender neutral, women were almost exclusively arrested for violating it. And the court case presented a lot of evidence to that effect, and I just want to briefly go over a few of the facts that were presented to the court. First, the court noted that the police officer in Providence who was in charge of the prostitution arrest testified that from 1959 through 1975, right before the lawsuit was filed, prosecution for violation of the prostitution statute was primarily focused at females. Though males were arrested, they were not prosecuted, but were rather used as witnesses to prove the crime against the female. That was a testimony of the Providence Police Department itself. And then there were some statistics presented before the court, and I'll cite a few of those. Between 1974 and 1977, 846 women were arrested and charged with prostitution. In the same period, 251 males were arrested, but the police were only able to provide evidence that 3 of those males were actually charged with the crime. The police department also acknowledged that it used a total of 55 male undercover officers for prostitution investigations during the 1974-77 period, while employing no female undercover officers at all in 1974 and 1975, and 4 female officers in 1976 and 1977. And it was only with the filing of the lawsuit that the police department changed its practices in that regard. So fast forward a few years, discovery is being taken, depositions are being taken, the case is still before the court. And while the court was preparing its decision, the General Assembly amended the law. And this is 1980. And it did so for 2 reasons. First was the obvious one. There was this lawsuit hanging over the state's head, challenging the constitutionality of it. In addition, there was a large public outcry on the west end of Providence at the time, where there was apparently some very overt street walking taking place, hard to miss, out in public, and it generated a great deal of consternation in the community. It prompted public officials and politicians to get involved in trying to deal with it. And the solution they came up with was to streamline the legislation in a few ways.
Mr. Brown,
Yep.
I would like to offer you the opportunity, if you are comfortable, if you like, to remove your mask. I don't want you to feel rushed, and I don't want to make you feel stifled with it on while you're speaking to us. So if you're comfortable,
Okay.
you're more than welcome to remove it and speak.
I appreciate it. Are people having trouble hearing me?
No.
I'll go on this way for a little bit, and then I may take it off after my mouth starts getting very dry. Thank you. So as I was saying, public officials concluded that what they needed to do was streamline the law in a few ways. And the first one was to not make it a felony. That required a lot of legwork, casework in Superior Court. So instead they decided to make the crime a petty misdemeanor, which would allow for speedier convictions, not necessitate the right for a jury trial, and also limit the appeals that individuals could bring. They got rid of they changed the crime of, they added the phrase for pecuniary gain into the statute. to specifically have it address commercial sexual activity. And they deleted the prohibition against committing the act of prostitution itself or any other indecent act. As a result of those changes in the law, as well as a change in Providence's enforcement of the law, all the parties agreed to dismiss the suit as moot in 1980. Now, I want to quote a few sentences from the court decision in which was acknowledging dismissal of the case, because we have always pushed back on this notion that there was a loophole in the law that nobody knew about, it was unintentional, and it needed to be addressed. So here are some quotes from the court decision in 1980, a published court decision. The court, looking at the new statute that the General Assembly had just enacted, said, "The statute is now directed at suppressing specifically that type of sexual activity commonly regarded as prostitution. More significant for present purposes, the amendments appear to have decriminalized the sexual act itself, even when undertaken for remuneration. Thus, it appears to the court that the statute now outlaws only certain preliminary or preparatory activities, and then only when pecuniary gain is somehow involved. The core of plaintiff's claim was that the state could not constitutionally bar consenting adults from engaging in purely private sexual activity, irrespective of whether the motivation of one of the participants was economic. As the court reads these new statutes, they do not purport to outlaw that activity." So I don't think it could have been clearer at the time what the General Assembly had done, what the impact of it was. It was there in black and white in the federal court decision. Fast forward 18 years, in 1998, the Rhode Island Supreme Court issues a decision that essentially affirms this clear reading of the statute that the federal court had made in 1980. This case involved a person who lured women into posing as models for him and sought to videotape them and have sex with them with the alleged goal of creating pornographic movies. This person was charged with a number of violations of the law, but including a violation of the soliciting for prostitution law. And the Rhode Island Supreme Court said, "We believe that the legislature enacted this statute primarily to bar prostitutes from hawking their wares in public, whether this is done by strutting up and down a public street or by calling out to passersby from the shadowed stoop of a privately owned building. Because the statute is directed at the public solicitation of prostitution, its reach simply does not extend to this activity when it occurs within the confines of private residences. Although other sections of the Penal Code prescribe the defendant's challenge conduct, this statute does not." So this is 1998, so we're 18 years forward without this statute being able to be used to address truly private, consensual sexual activity. And Rhode Island had not gone the way of Rome. Nobody seemed to care or feel there was a problem with the lack of a broader statute. Then finally in 2003, after there was a lot of publicity about an attorney getting a number of prostitution charges dismissed on the grounds that there was no basis for them under the 1980 statute because the conduct had not occurred in public. It was purely private and purely consensual. Those charges were dismissed, and then at about the same time, the city of Providence began examining the rise of the so-called Asian spas in the city and began conducting raids on those spas. The rationale for them at the time was that sex trafficking was occurring in these spas, and some, if not all, of the people engaged in prostitution at these spas were the victims of sex trafficking. And that was generally what they hung their hat on throughout what became 5 years of a legislative battle here in the General Assembly to reinstate the criminalization of indoor prostitution. Now, one thing that we pointed out at the time when Providence first introduced the bill in 2005 was that there was nothing that prevented them from going after sex traffickers. While it was true indoor prostitution itself had been decriminalized, there were a handful of laws that remained on the books that were felonies that would apply to individuals who were engaged in trafficking. There were laws against pandering, hold on one second. There were laws against pandering, harboring, and deriving support or maintenance from prostitution. All felonies that remained on the books, notwithstanding the changes in the 1980 law, and all of which could have been used to prosecute individuals who were in fact engaged in trafficking. So we had argued from the beginning that is not a legitimate rationale for reinstating this current allowance of indoor private activity. It's also worth noting that at the time, there wasn't a problem of police arresting people for prostitution. We looked at the statistics, and if you look at the Department of Corrections ACI population in 2008, just to give an example, right before the law passed, the number one criminal offense that women were in the ACI for, either pre-trial or after conviction, was for prostitution. That was the number one offense. So there certainly was not a problem of individuals not getting arrested for prostitution, even without changing the 1980 law. We were also troubled by a few other things that were occurring at the time leading up to the passage of the law and the city's attempt to address the problem of prostitution. One was an argument that some officials made that they were arresting the prostitutes, the alleged victims of the sex trafficking, as a tool to force their cooperation with police. That is to get them to give them information about who these traffickers were. We found that morally reprehensible as an extremely cruel policy. And it also was hard to understand why anybody believed that if this were happening, people wouldn't be afraid to do that. But that was a rationale given. And then related to that, unfortunately, another very disturbing aspect of the raids is that the city began collaborating with ICE, with immigration officials. And were contacting ICE when they had immigrants, women who were being charged with this offense. And a number of them were handed over to ICE and ended up, before being deported, often ended up being detained for months longer than they would have been if they'd actually been convicted of the crime of prostitution. But anyhow, notwithstanding all those concerns that the ACLU and a number of other organizations raised, the General Assembly did pass the law in 2009. But there are a few aspects of the law that I think largely went unnoticed, or at least are unnoticed now, that I think are worth mentioning. First, with all this talk of sex trafficking and the need to protect women, and that's why we're doing all this, the law as it passed actually provided very limited protection for women who were supposedly the victims of trafficking. What it did was it allowed them to establish an affirmative defense that they had been coerced into engaging in prostitution. That's a very heavy, and we would argue unfair burden to place on them. It's hard to do. As I mentioned, I think it's also hard, just as a practical matter, for anybody to snitch on these individuals who may have had their lives in their hand if they were in fact victims of trafficking. But the burden was on them, so that meant they would get arrested, they might get detained at the ACI, go to trial, and then at trial present as their defense that they shouldn't be convicted because they were victims of human trafficking. That's a very, very difficult road to ask anybody to go through, much less individuals who are allegedly victims of sex trafficking. A second thing that was added, that was included in the bill that became law, was a provision allowing for the seizure and forfeiture of any property that a woman owned that police claimed derived from the proceeds from prostitution. So as a result, under the very low burden that exists under the state's forfeiture laws, women could lose what little money or property they had as a result of an arrest and conviction, making, if these are people trying to turn their lives around, obviously making it much more difficult. And then a year later, the legislature amended another law that actually imposes special court fees specifically on individuals who plead or are convicted of prostitution offenses. It is a separate statute focused specifically on prostitution. So that was the 2009 law. So now I want to move forward and look at the past 5-6 years and see where we are, see what's happened. I think we all know every so often a prostitution street sting is conducted by a local law enforcement agency. The sting receives some media attention, but ultimately it has no lasting effect other than, in our view, embarrassing and penalizing consenting adults who've been engaged in sexual conduct for a fee. And by humiliating and giving arrest records to these individuals in the name of helping them, we think the law's major effect is just to make the lives of sex workers more difficult and dangerous. At about the same frequency, police will raid massage parlors or a strip club like the Foxy Lady and claim to have acted in an effort to address the problem of sex trafficking. I don't want to suggest in any way that this never happens, but it does. But all too often, there is this conflation of sex trafficking with prostitution that is simply inexcusable because that's not what ends up the result of these raids. It is the women who get charged, who get arrested, who get convicted, and there are no human sex traffickers to be found anywhere. I want to give just 2 examples because I think they highlight these points. In 2016, the Cranston Police Department conducted a sting operation, and they issued a news release announcing the results of it, that in its words, the police department's words, it was, quote, aimed at targeting human traffickers, specifically those victimizing juveniles. And according to their news release, no fewer than 8 law enforcement agencies were involved in the operation. According to the news reports, however, the sting led to 1 arrest for trafficking, 1 arrest for pandering, 14 arrests of Johns for procuring sexual conduct, and 14 arrests for other people for engaging in prostitution. That was the net result of that sting. The second one I want to mention, which got a lot of public attention at the time, but I think it's important to remember or learn for the first time the facts behind it, and that was the raid and the closing of the Foxy Lady in 2018. And I want to highlight it because I think it exemplifies what is wrong with these laws and with their enforcement. Although the Foxy Lady had been providing adult entertainment in Providence for decades, it had never been called before the Providence Board of Licenses until a police sting there resulted in 3 women being charged with soliciting for prostitution. The board then took the extraordinary step of permanently revoking the Foxy Lady's entertainment and liquor licenses and throwing more than 200 people out of work just a week before Christmas. It did so after concluding, without any direct evidence, that club owners had, and I quote, created an environment for tolerating prostitution, close quote. I want you to listen to that carefully. Note that the owners were not accused of promoting prostitution at the establishment. They weren't even accused of tolerating prostitution there. Their offense was that they had created an environment for tolerating prostitution, whatever that means. The unfairness is really compounded when you learn that the sting operation at the club was initiated because a female employee a few weeks earlier had been the victim of a sexual assault by a customer, and the club had sought the police department's help. But again, as a result of that, it was the women who bore the brunt of the punishment. These 3 women faced criminal charges. They had their names and their photos splashed across the media. And then dozens more were suddenly out of work and without a paycheck. Again, all of this is being done under the guise of protecting women. In one other respect, it actually gets worse. This permanent closure of the Foxy Lady, which was overturned administratively. But the true outrage was in comparing that permanent closure that the Board of Licenses issued with the penalties they'd imposed against other licensees who had much more serious trouble with the law. We did some checking. We went back a couple years and looked at the Board of Licenses actions in issuing punishment for other nightclubs that engaged in improper activities. And they included such things as a club where a bouncer had stabbed a patron, where a patron had shot a gun into the ceiling and the establishment deleted the video surveillance. And in both of those instances, the punishment was something like 2 weeks suspended license. So when you look at all the facts surrounding that particular incident, I think it just, as I said, I think it exemplifies some of the problems with trying to enforce these consensual laws. So as a result of all this, I don't think it should come as a surprise that the prostitution laws continue to be discriminatorily enforced. We filed an open records request with the City of Providence to obtain their prostitution arrest data for 2016 to 2019. And based on the information we got, they claim to have arrested 79 people on prostitution-related charges. 77 of them were for engaging in prostitution, only 2 of them for solicitation. 94% of the people arrested were women. We filed a similar request for Woonsocket, and it was similar. It was 89% women who were arrested. And we also found something extremely disturbing when we got the Woonsocket arrest reports. There were a handful of them where the police officer, in describing the incident leading to the arrest, and again, these are all stings, these are police officers looking for people to arrest. In a handful of them, the police officer described in their narrative of the arrest how the prostitute had asked them to squeeze or touch their breasts just to prove that they weren't a police officer. And the police officer obliged. And, to think that we are giving the police the power and authority to arrest people, and in order to do that, to engage in activity like that, I think should be absolutely condemned by everybody as another reason why this type of ban on consensual activity is simply completely inappropriate. Finally, we took a look at the uniform crime reports for Rhode Island because we also want to take a look at race issues. And we know that throughout the criminal justice system there are problems of race, and prostitution is no different. And you won't be surprised by the statistics we found. Out of all the arrests between 2015 and 2018 for engaging in prostitution, according to the uniform crime reports, almost 25% of the people arrested were black. In 2019, it was actually the only year we found where it was actually much lower, but if you combined it with the Asians who were charged with prostitution offenses, it was 31% of the people arrested in 2019 were either African American or Asian. So that is the history of prostitution in Rhode Island. I think it paints a pretty clear, consistent, and persistent picture, and one that we think really needs to be addressed. So I want to end with offering some of our suggestions for recommendations that we hope this commission will consider. I will note that if you look at the National ACLU report, they also have a number of much more, big picture recommendations that I encourage you to look at. Mine are much more specific. I mean, first, as politically infeasible as it might seem, we would urge for the decriminalization of prostitution. As an alternative, we would at least argue, based on the information I provided, based on the way the law has been implemented and enforced, that this commission consider recommending, at the very least, going back to the pre-2009 status quo, where truly private activity is not criminalized, and only the public display of conduct relating to prostitution is criminalized. That would be a significant step forward. While we recognize that either of those options may take a little time, will not occur this year, although I wouldn't underestimate the chair. I do want to just go through a list of smaller recommendations that we think also, in the meantime, should be considered. Number one, repeal the provisions that were added to the 2009 law that allow the police to subject a sex worker's property and money to forfeiture proceedings. And by the way, I will put this list of recommendations together in a document that I can share with you. Two, repeal the statute that requires those convicted of prostitution from paying extra court costs. Three, bar police from contacting immigration officials about women that they have arrested for prostitution. Four, remove the stigmatizing statutory requirement that any woman convicted of prostitution have an HIV test performed on them. Five, repeal a statute that imposes additional penalties for engaging in prostitution within 300 yards of a school. I don't think this activity is occurring at 11 o'clock in the morning. I'm not quite sure why a law like that is on the books, but it is. Six, once a woman has claimed she is a victim of coercion or trafficking, place the burden of proof on the police, not the woman, in order to obtain a conviction. Seven, enact legislation that's been introduced this year and last year by Representative Henrys to address, make very clear that police officers cannot engage in consensual sex with anybody who is in their direct custody. And finally, consider the use of non-incarceration penalties in the statute. Eliminate all the fees, court fees and costs that are imposed on individuals who do end up getting convicted or plead to the crime of prostitution while it continues to be a crime. So in conclusion, I just want to say in 2009, we believe the General Assembly made a terrible mistake in passing this harsh law. All it has done is, once again, make criminals out of people engaging in consensual sexual activity and put sex workers in more, not less danger. We think it is time for a fresh review of that law and the adverse consequences that have flowed from it, and we hope that the Commission will take action to address these inequities. And with that, I will be glad to answer any questions.
Well, all right. That was definitely very, very interesting and rewarding. And I would like to also enter into the record that Dr. Philip Chan is on virtually. He's present. Michael DeLauro is also here. And Lelena Shai, is also present. And, oh, yes, sorry. Thank you.
Yeah, Henry Binks is online.
Okay. Hi, Henry.
Hello, thank you so much for having me.
Okay, so that concludes that record of other additional members to the commission. Are there any questions to Mr. Brown? Bella?
Yeah, Mr. Brown, thank you for your great report. I hope you can email it and share it with us. And when you were talking about Foxy Lady, we did a lot of research around this that mimics much of yours. We found that police officers were being paid overtime by the club, so it's kind of ironic that they created the environment, right? And we also want to acknowledge that Lindsay Hoffman, who's a member of Coyote, because of the support she got, fought her case and was found not guilty at trial. After her name and picture was smeared all over New England News, she was a mother with a 7-year-old daughter. Over the last 2 years, we surveyed 79 local dancers when we gave out COVID grants and asked them if they liked their work conditions, if they felt safe. And then I don't know if you remember, last year, Providence City Council wanted to ban the VIP rooms, and we stopped that. But I think it's an interesting concept that we have police officers in these clubs. They don't even do this in Vegas, where they're heavily regulated, and that maybe that's part of the problem. Thank you.
Are there any other questions? Proceed. Any questions? Yeah, I have one. Oh, did you have one too? Proceed. Yeah.
We're all so polite. You go, you go. I had a question. So on some of the recommendations, are these repealers for the repealer bills, or are these actual recommendations? Because some of them seemed that they were gendered language around women specifically, or are these for all genders? And that was the first question. And the second part to that was, I think it was obviously the overall is like wanting to recommend decriminalization, but the lesser recommendations were some of those like imposing of, rolling back on the I don't know if you can go back to it, but some of the fees and these kinds of things. But I think you said women, and so I just wanted to make sure that it wasn't specific to gender, that this is for all genders as well.
Yeah, it is not. I mentioned at the beginning of my presentation that I was saying women, but yes.
Okay,
it
so this
applies
was going to
across.
be for all people.
Yeah.
And then could you go back to some of those smaller recommendations too? I know you are going to send this to us afterwards, but I had one more question after you had mentioned the repealing, sorry, not repealing, but like turning back the, going back on the fees. It was after that. What was the recommendation for that?
It was repealing the statute that imposed, well, there were two things I said about fees. One is I mentioned there's a specific statute about prostitution offenses itself that imposes fees, and we urged the repeal of that. But we also separately urged the repeal of the other court fees and costs that are imposed as a general matter when somebody is convicted of a crime in court here in Rhode Island.
Got it. Okay. And if I remember my other question, I will circle back to you or email you directly. But there was another one, and I can't remember it right now. Thank you, though.
Thank you. Michael?
Steve, thank you so much. That was a superb presentation, as is your want, that I've been listening to for many years. One of the things I wanted to point out, this, and maybe it's less of a question and more of a just kind of getting the lay of the land where the rubber hits the road. There's a Rhode Island Supreme Court decision that has informed my practice for the better part of 4 decades. In Ray Lamarine, I don't know if you're familiar with the case or not. So In Ray Lamarine dealt with a young woman who was arrested for loitering for the purposes of prostitution. And these are the facts of the case that the Supreme Court found satisfied that particular statute. Bear with me for a second. There it is. So here are the facts. Here's what the court said in finding that this woman violated her probation. And here is the facts of the case as recited by the court. The facts and information reveal that the hearing established that Lamarine waved at and attempted to call over to the curb only those cars that were occupied by males, and that on one occasion she left with a man in a red car, returning to the same area in the same car 15 minutes later and resumed her prior activities. From this testimony, the trial judge needed to draw but one inference in rendering his decision, that Lamarine's purpose in stopping male-occupied vehicles was for prostitution. Indeed, as was the trial judge, we are hard-pressed to decipher any logical explanation for Lamarine's behavior other than that she was loitering for that purpose, therefore the evidence was sufficient. Now, the reason I'm bringing this up is I'm old enough and practicing long enough to remember when this case came down. And what we saw in the trenches of the district court was every single police report, back then they were called BR2s, I don't know if anybody remembers that. Every single BR2 read as if they were cut and pasted, and we didn't have cut and pasting back in those days, was taken right out of this decision. Now, it could very well be that that's how every single one of these cases goes down, and we litigated our fair share of them. This is a very long-winded way of saying that among the recommendations that you might want to consider is something that was embraced in the context of the Good Samaritan legislation, where you dealt with folks who were on probation. That's really important because a lot of these folks are on probation. And I've always wondered, the facts of that case, if that person had not been on probation, if there was enough there to sustain a verdict of guilt beyond a reasonable doubt. And you can imagine the litigation, right? One male motorist, not two, what'd they look like, but really, really hard to win when they're on probation. I don't know what your thoughts are on that, but I think it's important, I know it's important that the commission know about this, and whether it's, painful recollections of early on in my career in handling dozens of these cases and losing dozens of these cases. I wonder if you have any thoughts on how we deal with that issue.
I think that's a great issue. I think it does deserve attention, and we would certainly support coming up with some language to address that. Absolutely.
By the way, for the record, Madam Chair, if I may, it's a 1987 decision of the Rhode Island Supreme Court, and the citation is, hang on a minute, 527 Atlantic 2nd at page 1133.
Thank you very much. It's
By the way, thank you, Madam Chair. Thank you, Steve. Thank you very much.
It's disheartening, it's surprising, it's disappointing. I mean, you brought us some statistics, some information that's got my mind swirling around, and to hear, it's a man's world, and the women, boom, get the brunt of all of this, and it's a continuation from back in the day to current day. It's totally unfortunate. But what's good about it is all of the suggestions or recommendation that you presented here today, it's almost as we really don't need to study this because the facts, we know what they are, but we just have to go through this process of proof that it's discrimination once again. But I'm so grateful to hear it, and don't think you're off the hook, because I know you have other stuff left up in the trunk somewhere. So be ready, Steve, be ready. Elena?
Thank you so much, Steve. I think in particular, you really brought back to life what this has looked like in its historical trajectory, and in particular, this 2008 moment where you remind us that the ACLU back then is vehemently against revising this law. So I wanted to ask one question on that. And can you talk a little bit about what that coalition of opposition looked like back then? Who are your allies, but even more, who is the opposition that we were facing back then? Do you see that as the same opposition that we are up against now?
Sure. Well, at the time, as I mentioned, this was a 5-year fight. The bill was first introduced on behalf of Providence in 2005, and those of us opposed to it held back the water for 5 years, but in 2009, we couldn't any longer. The organizations opposing it included not just the ACLU, there were women's rights groups like Rhode Island Now that opposed it. There were national sex worker organizations that provided testimony against it. I can get you a list of some of the organizations that joined with us in opposing the bill at the time. In terms of the support, frankly, a lot of it came from legislators themselves. It was a hot button issue for some legislators who were dealing with prostitution in their districts. And again, not surprisingly, police, were claiming they needed these laws, stronger laws to address problems of trafficking and so forth that the 1980 law prevented them from doing. As I said, we argued that was not a legitimate rationale, but police, love to, the more arrows in their quiver, the better, and this certainly provided more arrows to address whatever issues they wanted to address when it came to prostitution.
A follow-up question.
Okay, yes, sorry. Follow-up question. Thank you so much for, at the end of your talk, bringing us into the area of analyzing race in the data, and I just wanted to make an amendment or an addition. I think it's so interesting that in 2019 we have 31% aggregate Black or Asian, but I want to note that if we include numbers of Asians arrested for unlicensed massage, which becomes the new proxy to police prostitution under the 2016 Body Works Ordinance, then that number will be so drastically different. So I hope, we're just coming off of this very exciting win on Friday in New York. We launched a new bill in the Assembly to decriminalize unlicensed massage, and that's absolutely, I think, something that we could work towards here, since seeing as how, in New York, it's an education statute that they use. Here, it's an entire new law that is invented in 2016 exclusively to police Asian women. So I think the data there would, it would be even higher, the percentages. And then lastly, wondering if you have done any looking at the data on race and the policing of Johns, because I think overwhelmingly when you see these stings in the newspaper, it's like Asian women, Black and Latinx men, and we know that is not necessarily the population of people who are clients of sex work, so it's absolutely a criminalization of race and poverty issue for buyers and sellers.
Yeah, well, I think that's a great point. We don't have data on that. One of the problems, especially in, the two municipalities I mentioned, Providence and Woonsocket, there are so very few arrests for those soliciting prostitution as opposed to those on the other end that I'm not sure that the statistics would tell you very much.
You think there's some institution that would have that answer?
Well, it can certainly be, if we could certainly look through the arrest reports we received and see if that information is there, and I'd be glad to share it with the commission.
I mean, because it is important to also look at that. So if it's any way we could get that information, and if you need help with getting an intern to do that work to not keep you from having to give up extra time with other jobs that we're going to have you doing. it would be, just let me know, because I think that would be very important for us to have that information too.
Yeah, absolutely. But again, as I said, if 94% of the people being arrested in Providence are for engaging in prostitution as opposed to being the solicitors, it won't tell you that much, but it certainly doesn't hurt to get that information.
Somebody's going to ask that question when we do the report, you know what I mean?
Sure.
So rather be ready than use the time to get ready. Thank you. Justice?
So thank you again. That was very informative, and I definitely learned a lot. Also, thank you. I'm excited to be on a commission with folks who are very informed about the issue. I wanted to go back to the part you were talking about with policing, and particularly the instances where police did engage in some level of activity with the sex workers who were then punished. And I do think it's an absolute shame that our General Assembly has not passed a law to stop police from engaging in sexual activity with folks they have detained or they are investigating. It doesn't make sense that that would be allowed. But I'm wondering, are there any laws on the book to stop or to regulate how police interact with those they are investigating for sex work, for prostitution? Is there any bars on the way that they behave? Is there any protections for these, for sex workers against entrapment, for sex workers against being abused by those who are supposedly protecting them? I'll ask that first, and I have a follow-up.
That's a good question. There are certainly laws. There are constitutional limitations on what police can do. We would certainly argue in terms of sexual activity that it is per se non-consensual, and therefore the sexual assault laws apply. But I couldn't tell you how a court would analyze the type of situations I've seen in these arrest reports where they say, well, I just, let me tell you exactly what they said. The woman told me that if I wasn't a cop, she wanted me to grab her breast. I then brushed the female's left breast with the back of my right hand. So that's how it's often phrased. Whether that is something that could be challenged, I really don't know. But
Thank you. And I guess on the sort of same thread, and this is anecdotal, we'll have to get more insight and testimony from sex workers, but it's not a secret that there are police officers who engage or who solicit sex work or who partake in some form of sex work, whether that be prostitution or strip clubs or pornography. And so I guess my question is, what are the ways that we can protect those who might be engaging from being abused by systems? And even as you said with the Foxy lady, right, that raid only happened after the owner started working or reached after one of the employees was already harmed and they got police involved for that. And so I'm wondering, are there ways that as we're figuring out what to do for the commission, as we publish a report, we can make sure we're also thinking very specifically about making sure our public servants are not abusing their power to further harm sex workers or victims of trafficking?
Well, certainly in terms of sexual activity itself, there is the bill, the specific bill that's been introduced to address that particular problem. In terms of broader violations, this is an issue that we deal with all the time. Police violations of civil rights take place. I think I and Chief Wardell would disagree on how often it takes place, but there are remedies in the law for that. It's just that as a matter of constitutional law, the courts have set a whole bunch of barriers that make it difficult to pursue a lot of those charges. You may be aware, just to give one example, you may be aware there's actually a campaign going on across the country right now to address the issue of qualified immunity of police that protects them even when they do violate a person's rights. So there are all sorts of procedural actions that could be taken to address those barriers that exist, but they go much beyond any particular crime, prostitution or anything else. They're really systemic in making it difficult to bring civil rights claims in a variety of circumstances.
Any other? I would like to just make a comment with regards to, oftentimes when we say law enforcement or police officers, it's a widespread, it's a wide net that's put out there. And just personally, I have to say, because I have a couple of family members that are law enforcement officers, and it's not always all the police officers that are bad. Just like me, I'm comfortable saying what I'm saying because it's true. You know, there's those few bad apples that make the whole department look bad through states, cities, and towns. They're not all bad in my eye, because I know my family members are not Joe Rockheads or jump out boys and all that, and girls, because I have female and male that are in law enforcement. You have a follow-up, Justice?
If I can just very quick, I mean, I certainly don't want to suggest that we are saying that all police officers are bad, but I do think it is fair to say, with all respect to the many fine police officers out there, it is more of a police misconduct is more of a problem than the police themselves believe it to be.
Gotcha.
And if I can also respond to that point respectfully, Chairwoman, I don't think we need to make a distinction between the good and bad police. If a police system, if a police department is having issues of misconduct, then it is up to all of the police to stop that, and we have not seen that happen over the last several decades. And so whether there are good officers in departments is irrelevant to the fact that these departments continue to allow their officers to abuse folks. Even if it's one or two officers, that whole department is responsible.
I agree with you 100%, and thank you for that, Justice. You are right on point, because those other officers, they see it and they're not saying anything. They're going along with it. So it makes them just as guilty as the ones that are actually committing the crime. So I agree with you. Henry, you have your hands up. And then,
Can you hear me all right?
yes.
I just wanted to speak on what police accountability can look like in respect to officers' interactions with sex work. Presently up in Vermont, we are living under a recently passed Good Samaritan bill that offers limited protection for people caught in an act of prostitution if law enforcement gets called into an unsafe situation. This immunity also extends to minor possession drugs charges, and it does not protect people engaging in human trafficking. Tandem to that, Vermont is one of the many states pushing against qualified immunity. And I would recommend that this study commission tack that on to our proposals in the future. That's all.
That was a lot and appreciated. Thank you so much. Leah? Yes. Speak into the mic.
I would love to say something, but I wanted to recognize that we also had another person that was had their hand up on the Zoom
Robin?
as well. There you go, love.
Robin? Yes.
Met you
Thank you,
last
Jamie.
time. How you doing? There you go, Robin. Sorry, I forgot your name, but met you last time.
Yeah, Robin Lindy, Amnesty International. I was just hoping, Mr. Brown, thank you so much for your presentation today. It was really informative. I was hoping you could contextualize the practices or the policies governing police interaction with sex workers with other states in the U.S., or at least within, the region of New England. I just want to know how typical these policies are within Rhode Island, how typical they are elsewhere.
I really don't have a good sense of other states. I mean, we certainly know where prostitution is or is not decriminalized, and essentially nowhere. But in terms of any particular policies governing how these laws are enforced, that I don't know. If there are major differences in the way it's conducted in other New England states.
Thank you.
Are there any Leah, go ahead.
Sorry, I'm got used to the on and off button. Thank you, Justice, for what you said about police interaction in regards to sexual misconduct with sex workers. And I'm glad you jumped there because I was going to jump there. So, here. So I just wanted to kind of put the definition of non-volitional sex really quickly. It's a public health term. Non-volitional sex is sexual behavior that violates a person's right to choose when and with whom to have sex and what sexual behaviors to engage with and in. So non-volitional sex in domestic violence circles, this is a term that we use a lot to talk about when a person can consent to sexual activity. And a lot of people think about consensual sex in terms of, just before sexual activity happens, or even during, right? This idea of like continuous consent and before consent happens. But they don't always think about after. And in domestic violence circles, we talk about you cannot give consent to someone who controls your freedom of movement. So I just want us to think about that. And when police control your freedom of movement, you cannot give them your consent to sexual activity. So I wanted to ask you, Mr. Brown, if you all at the ACLU have opinions about this, non-volitional sex, and obviously I know how you feel about sexual interaction with police and when people are detained in their custody, but non-volitional sex after the fact, right, of consent when someone controls your freedom of movement, because it's in domestic violence circumstances, this is something we think about quite a bit. Consent, when you find out that someone actually controls your ability to be free.
Well, I can only speak in the governmental context. That's where, the ACLU gets involved, and in particular with police interaction. And I believe that the legislation that's been introduced to address that particular subject does encompass what you're talking about. So I don't know if I may be misunderstanding your question, but I think that the bill addresses non-volitional sex as you're describing it in the context of police actions.
Well, I think the bigger issue around kind of this qualified immunity is that, to me, as a non-attorney, there's always this kind of argument of like, is it justified, right? Is this sort of ends, in my view, right? As a layperson, I hear it argued out as, does the ends justify the means, right? That's the argument that I hear as a layperson. But I don't think it's an issue of, do the ends justify the means? To me, it's an issue of why hasn't Me Too hit the police departments? That's the issue that I see. And I think that we should be having that conversation rather than do the ends justify the means. So.
Yeah, I think, looking at these Woonsocket examples, as I said, any crime that would appear to give the authority of police to engage in that type of conduct is an argument for not allowing the police to be involved at all in monitoring that conduct.
Thank you.
Representative Agello, and then.
Thank you, Steve, for a really wonderful presentation, and I look forward to getting your list of action steps, and I look forward to moving further on this. I have one comment, and that is that we not lose sight of the real goal, which I think is decriminalizing sex between consenting adults. And that, I think, should be our goal, or that's my goal in being involved with this group. And I worry that we might go off into thinking that we've got to be sure that the Johns are being prosecuted as in the same proportion as the Janes, I guess, as the prostitutes. That's one piece of it. I don't think that would be a solution that I'd be happy with. So that's a comment. And then to Henry's mention of legislation in Vermont, I'd be very interested to see that language. That sounds like something really good to be doing here in Rhode Island. And then one other comment on the topic of police misconduct. That's something that some members of this commission are working on in other ways. The chairwoman has legislation introduced and has been working on dealing with the Policeman's Bill of Rights. And I have legislation regarding police internal investigations of police misconduct and the fact that it is very hard, if not impossible, for the public to see the results of those internal investigations. That extends beyond police misconduct with prostitutes or women they control, or I guess men too, or trans individuals, and but it extends to an awful lot of other stuff. And again, with Representative Williams, Chairwoman Williams, I just had contact with a police officer yesterday involving a security issue at my day job, and the contact couldn't have been better. Police officers are not all bad. I don't think anyone thinks they are. But we do have to get to weeding out the bad apples. Thank you, Madam Chairwoman.
Thank you. Question with Henry, is your hands up because you had something else to say, or it's just there from before? I just want to not pass.
Oh, I'm so sorry. I think that I just forgot to take it down.
Okay,
I apologize.
okay. I see Sid. Come on in, Sid. Yes, baby. Come on. I want to hear from you too.
Thank you, Madam Chair, and thank you, Vice Chair Ajello, actually, for making that comment. That the focus of this commission, if we start going off in directions where there's ulterior motives, we're not going to get the work done that we need to here. I'd like, first and foremost. Those of you that know me well enough know that I'm not here to protect an officer who may do something wrong, but I will also stand up for those officers, men and women that are out there and doing great work within our communities. It's unfortunate that we've gone down some avenues that are not completely accurate, such as talking about qualified immunity. Qualified immunity is strictly in place and has nothing to do with criminal activity by an officer. Can never be used in defense of criminal activity, and qualified immunity is in place when an officer does something that they feel is reasonably allowable and hasn't been proven otherwise that it isn't. So, I don't want to go down that rabbit hole and take up our time, because I'm sure Mr. Brown and I can, talk for hours with each other on these types of instances. But I just hope that the commission knows that I am here on behalf of the Rhode Island Police Chiefs Association, looking to work towards coming up with both the appropriate presentation and recommendations that we have been asked to do. But I do ask respectfully that we keep on topic.
Because there's a lot, we're working, we're getting stuff right on. So we have, first I would like to ask Henry to provide the information or the direction to obtain the information that Representative Ajello asked for. So that would be very helpful. Henry, you're still with us, right?
Oh, yeah, I just didn't want to interrupt you. Yep, I can absolutely make sure that the information regarding H18 in the state of Vermont gets passed along.
Thank you.
Absolutely.
We'll go to Michael and then to Justice, and then to Bella. Michael?
Thank you, Madam Chair. Steve, I know you've been coming up here a long, long time, and if you want to talk about a rabbit hole, I heard my friend Chief Wardell use that phrase. And this is really a rabbit hole. I'm going to ask you to go down the rabbit hole of legislative intent. So the changes that were made to the statute that the Rhode Island Supreme Court spoke about in 1998, where they said, I paraphrase, according to what you said, the legislature enacted the new law to prevent prostitutes from hawking their wares publicly. That was a 1998 decision from the Rhode Island Supreme Court, you said?
Yes.
Okay.
State versus the magistrates.
Okay. I should remember this, and that one I don't remember. My question, though, is the legislative change that the court was speaking about in that decision, when did that legislative change take place?
That was the 1980 changes to the law in response.
Okay.
Right after the Coyote suit.
Okay. So my real question to you is, do we think that, and again, we don't have a whole lot in the way of legislative history in Rhode Island. Back then, we didn't even record the hearings and let alone, I don't know if we saved the testimony that was received. But do you think the legislature, in the changes that it made, these 1980 changes that the court referenced, do you think that the legislature's actions were intentional, that they wanted to not criminalize private consensual sex between adults, or was it an oversight on the legislature's part? Is there any way of knowing that?
I don't think there is one answer to that. I think there are different answers to it, and both the Rhode Island Supreme Court and the federal court in 1980 was trying to determine what the purpose of these amendments were, and all I can rely on are the statements that were made by the court at the time. I think the 1980 decision is certainly more contemporaneous than anything else you're going to find. As you note, there is no legislative history really in Rhode Island, certainly not at that point. And it was from affidavits that, or either affidavits or a deposition, that the court spoke about this second reason. There was a lawsuit and then this West End controversy that was going on. And I think there were different people with different ideas. Some of it may have very well been unintentional. The focus was on dealing with public prostitution. That is what really generated the new statute in 1980. I think it's clear that it had to have been acknowledged at some point that by doing this, you're also getting rid of that. Whether it's sunk into everybody's head about what it actually meant, I think it varied. I'm sure some people understood it and just thought there is no reason to criminalize that sort of private activity, and others were thinking we need to deal with this problem. Here's the solution that some people have come up with. It takes care of the specific problem we want to deal with, and I'm not thinking about anything else.
Yeah. I mean, you know where I'm going with this, right? I mean, the work of this group is really important, but if you can say, well, been there, done that, where the General Assembly has already made a judgment that we don't want, 40 years ago, that we don't want to punish folks for private consensual sexual activity, that's something that I think is worth thinking about at least.
I agree, but I would say that the strongest argument is, this happened in 1980, and nobody was up in arms about it for over 20 years. Mm-hmm. Why, we can get along quite well without criminalizing this activity, and we did here in Rhode Island for over 20 years.
Absolutely.
That's great. Thank you very much, Steve.
Justice?
Yes, so I first would like to say not everything that is wrong is criminal, and not everything that is criminal is wrong. That's why we are here today. We are here with the charge of looking at legislation, the prosecution, the criminalization of those who are engaging in consensual sexual activity for economic purposes. The folks in charge of enforcing those laws, in charge of enforcing that criminalization, are the police. We have not gone down any rabbit holes. I have not heard any ulterior motives, and I quite find it, frankly, disingenuous to say that we have. To say that any comment that is made at this board has ulterior motives is completely disingenuous. Qualified immunity is connected because, unfortunately, some of the wrong that police commit isn't criminal because they are police. That is what qualified immunity helps do. It helps make sure that police have an extra defense, and sometimes the things they do might not be seen wrong by the eyes of the law. So it is relevant to this conversation. It is not a rabbit hole. It is quite important for the folks who we are speaking about today, for many of our community members, to make sure that we are thorough in our investigation of this issue. And so I would like to ask you, Stephen Brown, what are the ways in which, with qualified immunity being also national, what are the ways in which this commission, in which as a state of Rhode Island, we can push back on looking at the protections that our public servants and law enforcement officers have against being charged or being held accountable when they do commit wrong for the ways that they enforce our laws?
That's a
Yeah. Dun, dun, dun.
that is a big ask. I would certainly be happy to come up with to share with you a list of recommendations that have been offered nationally, to deal with these often court-made restrictions on pursuing civil rights complaints against police and against other government agencies as well, frankly. Certainly the one that is most out in the open right now is qualified immunity, which as I mentioned is being discussed in legislatures across the country. But I could come up with a list of other police reforms that are being recommended to deal with other barriers that court decisions have imposed in trying to vindicate civil rights.
Can you, Steve, can you just add that to the package that you'll send?
I am doing that.
Thank you. Bella?
Thank you. So I've got a couple statements to make and then two quick questions that might clear up some things that people had asked. So,
Come closer to the mic.
oh, I'm sorry.
Yeah, push it back up.
Thank you. So 3 years ago, the bill H6637 was originally 0249. We used the word peace officer because it included police officers, probation officers, correctional officers, anyone that had the power to threaten you with arrest, put you in a cage while you were detained or in custody. This year, we asked it to be amended to include people under investigation. We know all through the United States, some police officers engage in sex to completion and then arrest the woman and seize her assets. That's clearly state-sponsored rape. They're also using force, coercion, and fraud, lying about the fact that they're not a police officer, which is kind of ironic because that's the definition of trafficking. I also, upon doing FICO request, we had some departments that did not give this, all of them to us that we remember seeing in the police log or on the news. So we want to come up with a better system, and we spent a lot of money, and we reviewed thousands of pages of charging documents. And in some cases, we did run across things like Mr. Brown said, where they admitted groping the woman. But we also need to take into account that this is only their version of the events, and not the person that is affected and being arrested with them. Lastly, I wanted to ask Steve Brown, I'm sure someone's going to bring up the Nordic model before we're done, which means we're going to criminalize the clients and not criminalize the women. And based on Coyote versus Roberts and what we see with the majority of people being arrested being the women, wouldn't the Nordic model be unconstitutional on its face? Men are criminalized, women are not. I know you might not have a legal answer right now, but I just kind of wanted to put that in people's minds. Thank you.
Did you want to answer?
Well, just that, I agree with the comments that Representative Agello made earlier on, that the solution, certainly, leaving aside legal issues, the solution is not to punish more people. It is to decriminalize the activity as a whole, and yes, you are not solving the problem, you're just creating different ones if you look at the other side of the equation instead of the one that is currently bearing the brunt of enforcement.
Okay, thank you. Charlotte?
Hi, Mr. Brown. I had a quick question, mainly a clarification. Earlier, when you were addressing in the study about what seemed to be a large amount of collaboration between organizations, of course, we'll see once the entire document is provided, but just ahead of that, I'd like to ask if the full extent of those collaborations is addressed, because just as what I felt like seemed a bit of an inference is that a good portion of the sort of trafficking aim seemed to be creating an artificial backdoor for a lot of these other collaborations. And I was unsure if this would be addressed through just analyzing the prosecution level of these, of how this is addressed, or if this is a specific study that would be addressed through the ACLU.
I'm not sure I quite understand the question.
Just specifically, my question is just as to the extent of the collaboration between law enforcement and other organizations such as ICE and so on, to kind of tack on additional crimes to those arrested for initially for trafficking and or sex work.
Yeah, the collaboration that was taking place at that time, it really wasn't to impose additional criminal charges against them. It was to deport them. It was, knowing that they were in undocumented status, or suspecting they were. I'm not sure whether they knew all the time, but then contacting immigration officials to have them prepared to detain these women for being in violation of immigration laws. And it was one of the tools that the police department used to deal with the issue at that time. And it's one that still, comes up now. I mean, there are immigration groups in Rhode Island, have been pressing for policies to limit the collaboration of police with immigration officials. Some police departments on their own have adopted policies to do that, recognizing the importance of promoting trust in the community. And, that is to be commended, but there's no statewide prohibition on that type of collaboration, and it still occurs to this day. But it seemed especially obnoxious in the context of arresting women supposedly because they were victims of human trafficking and essentially trading one set of bars for another.
Okay, are there any, are you finished, Charlotte? Thank you, Steve. Are there any other questions? I want to just state that this was definitely 2022 and we came ready. I really and truly appreciate it. As I had mentioned, I was going to try to keep the meetings to an hour. If no one has a problem with it, we went over, we started maybe about 5 minutes after the hour, but if no one has a problem when the conversation is juicy like it was today, if you don't mind just going over the time, I want to be respectful of everybody's time. So an hour we can have in mind to have the commission meeting, but with the understanding if we need to go over just slightly, if there's no problem with that with anyone, I will greatly appreciate it. But I thank each and every one of you for being here. We had all 13 members in present and everybody engaged. And Stephen, you knocked it out the ballpark. And I greatly appreciate everyone who asked the questions, made their statements, and certainly been here and will be back again. And I will ask Dr. Chan, if you could reach out, I need to speak with you because I want to put you on the hot seat. So hopefully you'll get to me at your convenience. I'll greatly appreciate it. And with that, if there aren't any more questions or statements, I will entertain a motion for adjournment until the next time.
Madam
Motion-
Chair, move to adjourn.
Second.
It was moved and second. All in favor to say au revoir until next time, say aye. Aye. Thank you very much.